Dharmendra Pradhan, the former Union Education Minister, took moral responsibility for the failure of his ministry, be it in terms of paper leaks or whatever else. He addressed the resignation letter to the Honorable President of India. He had to because under Article 75, Sub-Article 2, he is there in power as long as he enjoys the pleasure of the President. And before that, there is another article, the Article 75, Sub-Article 1, in which it is said that the President of India appoints the Prime Minister, and on the advice of the Prime Minister, he or she appoints the other ministers. So you address your resignation letter to the authority that has appointed you, which is the President. So the President of India was the authority to which the resignation letter was addressed. But the important point here is to understand that, like Lal Bahadur Shastri in 1956, who resigned because of railway accidents, he happened to be the railway minister then, took moral responsibility for it, voluntarily he quit. Here is the case repeated. A minister takes moral responsibility, holds himself accountable, and then resigns. Is there any other way the individual minister can quit the Council of Ministers? Yes, of course, there are two other ways. Go back to 1951, Dr. Ambedkar. He resigned because he wanted a Hindu code bill which put men and women on equal keel. The gender equality in terms of property, maintenance, inheritance, divorce, marriage and whatnot, all the personal laws. And the cabinet wasn't ready for it. And therefore, he quit because he disagreed with the Council of Ministers, collective responsibility. I'll come back to that. Again, in 1956, in the state's reorganization, the city of Mumbai, the Union Council wanted to give it the status of a UT, and C.D. Deshmukh, the former RBI governor, deferred, and so he resigned. And then you had in 1986, there was a resignation by the Union Minister for the Cabinet's decision to reverse the Shah Bano case verdict of the Supreme Court, where under the CRPC then maintenance was ordered by the Supreme Court and the Union Council of Ministers wanted to reverse it, and the Honorable Minister resigned. So this is when you differ with the Council of Ministers, and Dharmendra Pradhan's case is moral responsibility. But it is also possible that the Prime Minister can tell the President to sack, dismiss a minister. It happened twice that I can recall, maybe only twice. One, in 2005, Natwar Singh was dismissed by the Honorable President of India because of some scam related to the United Nations and so on. And there was in 1990, Devi Lal, the Deputy PM, was sacked on the advice of the then Prime Minister V.P. Singh to the President of India then, Venkataraman. So twice they were sacked, and so many times they resigned because they deferred with the decision of the Council of Ministers. And here and there, that is Dharmendra Pradhan and the previous case of Lal Bahadur Shastri, the ministers resigned, taking up the moral responsibility. Now, let us see how an individual minister is held responsible, accountable. For example, you have in the parliament you have a question hour where there are starred questions where the minister may be asked to reply orally, and if he doesn't give the right response, found to be misleading, then there can be a privilege motion. And if the privilege motion is successfully passed, then the Honorable Minister will have to apologize, or the case may even go to a point where the Honorable Prime Minister may sack him. So that is the oral question issue. Then you have the censure motion where under the Lok Sabha rules, you have a no day yet named motion category in which a censure motion can be taken up, in which the reasons have to be given to censure, severely criticize a single minister or a group of ministers, giving reasons why you are criticizing them so severely. And if the motion is passed, then again, of course, they don't have to resign, but it's up to the Prime Minister to take as seriously as he wants the entire issue of a censure motion being passed. All these are there on paper, but they are never actually exercised, because to move a privilege motion and get it through, to have a censure motion successfully passed, you require majority in Lok Sabha, and that majority is with the union government. That is the government which has numbers in Lok Sabha. So yes, but on paper they are there. Even the debate is a trigger for formation of effective public opinion. So individually, the minister is responsible to the appointing authority, the president, but is accountable, answerable to the parliament as well. Removing authority and appointing authority are the same, but accountability is also to the parliament. That is how the minister can, on moral grounds, number one, on his differences with the Council of Ministers, number two, or on being sacked, number three, he quits the Union Council of Ministers. He can remain, he will remain a minister. You are seeing Dharmendra Pradhan come to the parliament and take part in the proceedings of the parliament. He has resigned as a part of the political executive, but he has not quit the parliament, on the basis of which he became the member of the political executive. Now, we have seen Article 75.1, which is appointment of the Prime Minister and on his advice other ministers by the Honorable President of India. Article 75.2 is very important, Doctrine of Pleasure. Tomorrow you will all be civil servants. You are there in government as long as you enjoy the pleasure of the Honorable President. Here in the case of Dharmendra Pradhan or any other minister, that pleasure means that if you are functioning well, if you are up to all legal and moral norms, it is your job is secure. Unless you are held responsible for all that you do, unless you are politically answerable to the parliament, unless your conduct is fit and perfect, the President of India's pleasure may not be available. So basically it means that you have to be accountable, your conduct has to be good, your character has to be good, your policies must be good. Only then you enjoy the pleasure of the President. Now, what is this pleasure of the President? We have been reading in the books and outside that the Honorable President of India doesn't have any substantive effective powers. So here is the fact of life. That is, de jure, on paper, in law, it is the Honorable President whose pleasure the minister must retain in order to continue in office. But de facto, in fact, on ground, it is the Honorable Prime Minister. Article 74 clearly states, after the 44th Amendment Act, that there shall be a Council of Ministers headed by the Honorable Prime Minister of India, whose advice is the basis for the functioning of the President. That is, the President functions on the aid and advice of the Council of Ministers headed by the PM. PM is not first among equals. He is not primus inter pares. He heads the Council of Ministers. That is formally, constitutionally stated in Article 74. So, here is Dharmendra Pradhan resigning and the President accepting the resignation according to the Rashtrapati Bhavan communique. And the legal fiction is it is the President who accepts. That's a legal fiction. In reality, it is the Prime Minister who under Article 74 advised the Honorable President under Article 75.2 to accept the resignation, because the power of the minister exists only as long as he enjoys the pleasure of the President. Now, what is the legal responsibility in India of the minister? See, in Britain, there is the crown, the monarch. The monarch gives orders. The same order is countersigned by the minister of the department. Countersigned means supporting signature. The legal responsibility is that of the minister. He can be hauled into the court for explanation as to what he has done. Personally, he is not responsible, and the nullification of what he has done in his official capacity doesn't spill on him. He is not liable, but he can be hauled into the court because he countersigns. In India, the minister doesn't countersign. The minister is not there on paper at all. The President of India takes the action. And the legal responsibility is that of a civil servant who signs on the order in the name of the President. I'll come to Article 77 in a minute. Now the point is, Dharmendra Pradhan is not legally responsible to anyone at all. He doesn't countersign. It is the President who signs the order. In the name of the President, a civil servant signs. That's another matter. Now, who is legally responsible? What is the legal course of action here? Minister is not legally responsible. He is not signed at all. President has signed, though in an indirect way, but the President says, I am a ceremonial institution. How can you call me into the court? You cannot. And who is the man behind pulling the strings? The Prime Minister. But the Prime Minister says it's the President who has done. So neither the Minister, nor the President of India, nor the Prime Minister, none of them is responsible for what happens. Official acts can be undone in a court of law, but personal liability, none of them has upon themselves. So this is the legal responsibility part. Individual responsibility, the minister is responsible to the appointing authority, Honorable President. He is also answerable to the Parliament, because Parliament, by the many channels I have detailed just now, holds the Honorable Minister accountable. How does it operate in Britain? You know, all of us know Britain doesn't have the written constitution. It has unwritten constitution. That is, all the conventions have built up, all the customs have built up, all the historical practices have accumulated. All of them together are the foundation for the operation of the British parliamentary system, otherwise known as the Westminster system. We have adopted the Westminster system, but not every part of it. We have broadly adopted it. So in other words, it is the crown there, it is the President here, they are comparable institutions, and the President of India, like the crown, does not have effective powers. The king can do no wrong. He cannot be hauled into the court. She cannot be hauled into the court. Just like the King of Britain, even in India, the President is not responsible. And in India, the minister doesn't countersign. There, the minister countersigns. So the legal responsibility is not that of the minister here. The legal responsibility for the official acts does not devolve on any single person. It is the official act, keep it or nullify it. Either way, it does not fall on the persons behind. And what is the substantive difference between UK and here? None. Only legally, formally, you have the minister brought into the court of law there. In India, there is no such mechanism, and you can question the act on the basis of Article 32, 226, because your fundamental rights are violated. So, I want to take you back to collective responsibility that I have hinted at. Individual responsibility, including a comparative account of India and Britain, we have talked about. Now I want to talk about collective responsibility. We have a plural executive. That is, ministers headed by the Prime Minister make up the political executive. Unlike in America, where you have the President of America, a single person holding the entire authority, he is held accountable. There it is the individual, that is the President of India, who is responsible. Here in India, we have Prime Minister heading about 80 strong ministry, and they are collectively responsible. The Prime Minister himself doesn't take all the decisions. He may suggest, like any other member of the Council of Ministers may suggest. All of them together sit together and take a decision. While taking a decision, they can differ with one another severely, deeply, heatedly. But once all that is netted out and a decision is arrived at, that decision is binding on the entire political government. None of the members who may have criticized while the decision was being taken can air any serious differences with it in public. After the decision is taken, if they have any differences, they can air them within the Council of Ministers meeting. So they swim or sink together. So what does Article 75 say? .3, sub-article 3 say? It says the entire Council of Ministers is collectively responsible to Lok Sabha. That is, Lok Sabha can hold them accountable through questions and adjournment motions, censure motion, calling attention and what have you. If none of them succeeds, you are responsible to Lok Sabha. Therefore, rules of conduct, rules of business of Lok Sabha, rules of procedure and conduct of business of Lok Sabha, they say that under Rule 198, no confidence motion can be moved against the Council of Ministers if the Council of Ministers is found to be lackadaisical in its accountability to the Lok Sabha. Successfully passed, the government has to quit. They have no choice. And they can defeat a bill also. If the bill is successfully passed, next step is confidence motion. That is suo moto. The government will come forward to Lok Sabha saying this house is having confidence in the ministry. Remember Atal Bihari Vajpayee 1999. He came with a confidence motion. This house has confidence in my ministry. They said, no, we don't have. And so he had to resign in 99 and come back. He got elected with a much better majority. He came back. That's another story. So Lok Sabha holds the Council of Ministers accountable, and if the confidence motion or no confidence motion is, in the sense the confidence of the House is withdrawn in the ministry, then the ministry has to resign. That is the entire ministry. Those who differed with the decision in the meetings inside the Council of Ministers, they can't say, we will survive with our ministerships because we never agreed with the policy in the first place. No, you swim or you sink together. That is a collective responsibility. Now you go back to Dr. Ambedkar, 1951, the first law minister of the Union government. He didn't agree with the Hindu Code bill, so he had no choice but to quit. And similarly, C.D. Deshmukh. So they did not agree with the collective response. They did not agree with the collective decision of the Union Council of Ministers. That is how they had to quit. That is the collective responsibility. Now you please come to Article 77, which is legal fiction. Which is, it says, the entire executive action of the Union government is taken in the name of the President, point number 1. Point number 2, thousands of decisions are taken by the government. All of them have to be taken in the name of the President. But the President himself can't sign on all that. The President, by his official power, under Article 77, sub-article 77.2, says a joint secretary or a certain other person, a civil servant, will on my behalf take the decisions. That is 77.2. 77.3 is, there are so many works that the ministries do. Some of them overlap. For example, Home Ministry, Defense Ministry. What does the army do? That the President will sort out. Irrigation, animal husbandry, fisheries, agriculture, soil conservation. All of them, they have overlapping functions. And for them to figure out is not proper because they'll have their own self-interest. So it's the President of India. It's a cabinet secretariat that does it. But in the name of the President of India, to whom the function is accorded under Article 77.3. So we have discussed the concept of individual ministerial responsibility to the President, appointing authority. collective responsibility according to the Article 75.3, that is to the Lok Sabha, not Parliament. Lok Sabha, House of the People. We have discussed 74, 75, 1, 2 and 3, 77, 1, 2 and 3. These are the articles we have discussed. This is the constitutional background to the resignation of an individual cabinet minister, Shri Dharmendra Pradhan, the other day, and the acceptance of the same by the President of India. Of course, on the advice of the Prime Minister, as stated in Article 74.